When lawyer Philip Slayton was pondering whether or not to write a book about the Supreme Court of Canada after a glass or two of wine, for the fun of it, he asked his legal pals to scribble the names on a napkin of Canada's 9 Supreme Court judges. Well, his pals slowly managed to do that, but it was easier for them to list the high judges in the United States of America. That and more intrigued Slayton to write a book called Mighty Judgment: How the Supreme Court of Canada Runs Your Life. He is a Rhodes Scholar, Mr. Slayton. He's been a law clerk at the Supreme Court. He was dean of a Canadian law school and a senior partner in a prestigious law firm. It is my pleasure to welcome Philip Slayton back to Studio 4 to tell us more.
Hello, Fanny. Nice to be here.
Nice to see you again on the heels of Lawyers Gone Bad, Money, Sex, Madness in the Legal Profession.
I'm glad you mentioned that book. It's still for sale.
Is it?
Yes, absolutely.
Well, it was a good book.
I thought so.
Mm-hmm. Why the Supreme Court? Why now?
Well, I first got the idea to write this book when I reviewed a book about the American Supreme Court, Jeffrey Toobin's book, The Nine, which is a book for a popular audience, a general audience. I thought to myself, just a minute, there's no book in Canada about the Supreme Court that a non-lawyer can get and read and find out about it. And I said to myself, that's a gap I can fill.
So I'm sure you had some preconceived notions at the outset.
I did. My original sort of idea going into the book was, just a minute, you have here 9 elite lawyers. As you said, nobody even knows their names for the most part. They're not elected to anything. They're appointed to the age 75. And since the 1982 Charter of Rights and Freedoms, they're making extraordinarily important decisions for the entire country. That's, I thought, undemocratic. That's a bad thing. We should change that.
So what changed in '82 when the Charter of Rights and Freedoms emerged?
Well, what changed was that the judiciary in general and the Supreme Court of Canada in particular were handed vast powers because the Charter, which is part of our Constitution, enumerates various rights and freedoms we all have in a very general way, but it doesn't really give them content, and it doesn't, of course, apply them. So guess who gives them content and applies them? The judiciary.
And you're suggesting some of the judiciary, perhaps all 9, are politicians in robes.
Yes, I do say that, but they're politicians not in the sense that they're a member of a political party.
Right, they're not elected.
No, but they're politicians in the sense that they make policy. They make social policy, economic policy, political policy, indeed, for the country as a whole. And of course, in doing that, they apply their worldview, their concept of how things should be, inevitably.
As I'm sure all judges do. Impartiality, yes. Neutrality, yes.
Well, I'm not so sure they're impartial and neutral. They're impartial and neutral in the sense that they don't subscribe to the program of a particular political party, for example. But they're not impartial and neutral in the sense that they don't have views on things. I mean, how can you become, how can you be an educated adult without having views on things? They have views on things, and inevitably, when they decide charter questions, I think those views have a big influence.
Very much so. We can go back to the Morgenthaler case because it's high profile.
Yes, well, and as you know, in the Morgenthaler decision in 1988, the Supreme Court of Canada said that the laws in our criminal code about abortion were unconstitutional and struck them down. And as a result, since then, we have no laws on abortion in this country whatsoever. The only country in the Western world of which that is true.
Do you think we should have laws
about abortion? That's a tricky question. I think we might get some laws on abortion soon, notwithstanding what the Prime Minister has said about this, because it's an issue that many people feel very strongly about, pro and con.
Hence the point.
Yes, and if we do get abortion laws in this country, you can be sure that those laws will be tested by the Supreme Court eventually, according to the Charter. And you can be sure, getting back to the point of the Prime Minister picking new judges, you can be sure that when he picks new judges, he'll have an eye to how those people might behave given questions like that to decide. Okay,
and speaking of picking new judges, 2 Supremes stepped down as of August.
Yes.
Sharon, who was it? Sharon and Binney?
Louise Charon and Ian Binney, the two Ontario judges.
Ian Binney?
Ian Binney, yes.
Well, tell me about him, because I don't suggest for 1 minute he's a loose cannon, but he seems to be, according to Mighty Judgment, a bit of a devil-may-care fun guy with a sense of humor.
I'm not certain whether devil may care fun guys, the qualities that you looked for first in the Supreme Court judge.
I don't mean he doesn't have qualifications.
No, he happens to be a favorite of mine. He's very iconoclastic. He's very smart. He's very interesting. He's very independent in how he decides things. And he also came to the bench, came to the Supreme Court with a great experience in private practice and elsewhere. And probably the most experienced judge when it comes to private practice. So he'll be a loss.
He will be a loss. Why did
and he is funny.
Why did that's good.
That is good.
Why did he resign? Do you know?
Well, he's 71, and I think he's been a judge, I think, for about 14 or 15 years. And, you know, it's a tough job. And I think probably he just had enough.
Okay, and Madame Justice Sharon?
Well, that's a different case. She's only 60. And so she had 15 years to go before the mandatory retirement age. Why does somebody at 60, in good health presumably, retire 15 years before they have to from a very good job? I don't know. Maybe she's just had enough too.
Well, sometimes, and if you don't like the job and you can go with a great pension and you've had fun on the bench or an interesting time on the bench, why not?
Well, I think you're right. Why not?
Do you think we should have a mandatory retirement of 75? Should we elect these judges? How should they be? Let's go there.
Well, we certainly shouldn't elect them. But I don't think either we should have a mandatory retirement age of 75. I'm in favor of something a bit different. I'd like to see a non-renewable 12 or 15-year term. Typically, a judge gets appointed to the Supreme Court, say, around about their mid-50s. There are exceptions, but that's typical. And so that's a 20-year run at least before they reach the mandatory retirement age. I think that's too long. I think they get burnt out, they get tired, they lose the freshness. It's time to bring in new people with new, fresh ideas. And by the way, also time to reflect rapidly changing demographics in this country.
What are some myths about the judiciary? You explore 4 of them in
Well,
the
the
judgment.
biggest myth about the judiciary is that they just apply the law that legislators make and don't make the law themselves. That's a total myth, certainly at the Supreme Court level. These judges make law. They don't just apply law, they make law and they make it up out of their heads.
Example.
Oh, many, many examples.
Okay.
I'll give you 2, for example, 2 references to the Supreme Court of Canada. One was same-sex marriage, in which the Supreme Court decided same-sex marriage was fine, it was constitutional. And the second was the Quebec secession reference, when they were asked, can Quebec secede from Canada? And they said, yes, Quebec can, but on certain terms following a certain process. I mean, that was just made up. And most of their big decisions are, in a sense, made up. They're not just taking the law and applying it in a mechanical way to facts. It's making up policy.
Lawyer Edward Greenspan, I believe, disagrees with you.
Well, with all respect to Mr. Greenspan.
He's not here.
He's not here. He wrote a critical review of the book in which he said, I didn't take into account Section 33, which is the notwithstanding clause of the Charter of Rights and Freedoms. It's a technical legal argument, which I won't bore you with. But the fact of the matter is, I just don't know what was in Mr. Greenspan's head when he wrote that. Not much, I think. Because Section 33 is widely recognized to be a dead letter, politically unacceptable to use, and so on. There are many criticisms perhaps you could make of the book, Fanny, but that's not one of them.
But that's not one of them. Okay. But it's not a subject, as you know, that would burn up a campaign trail or...
It should.
It should. But as you suggested, your pals, your legal pals, could barely remember the names of the 9 who are running our lives.
Well, and the average well-informed citizen, if you said to them, name a judge on the Supreme Court of Canada, you know, these are very important people. I think they'd be hard-pressed. Maybe they could name the Chief Justice, Beverly McLaughlin.
Yes.
Because she's quite high profile.
Because she was in county court here in Vancouver.
Yeah, she's a Vancouver person. But generally speaking, if lawyers can't do it, what chance the average citizen can do it?
Well, not big, but you said we remember some of the justices in the United States. Well, Clarence Thomas, who could forget him?
Yes. I mean, I think the point is that in the United States, judges of the Supreme Court are seen as, and see themselves as, important political public personalities and behave accordingly. Judges here do not do that. It's seen, you know, and Canadians are so deferential to authority, so polite, that they're perfectly prepared to accept that posture. I don't think we should.
So do you think at the Supreme Court level our Supreme Court judges should come out more, talk
Yes.
more to the press, be covered more intensely by the press?
I do absolutely think that. And they do make some efforts in this direction. I mean, the Chief Justice McLaughlin, makes efforts in this direction. But typically, if she or other judges go to speak to an audience, it's a safe, what I would call a safe audience. It's a law school audience. It's a bar association audience. It's the Empire Club of Toronto. One of the RCMP guards that protects the Chief Justice says, and I quoted in the book, said, you know, if I'm at a gathering where she's speaking and I look around the room and I see somebody who's not laughing and clapping, I get concerned.
But as you know, there are judges who do not like to attend anything that's political. Well, they're not supposed to, but
no.
Do you know what I mean? They can't come out with their own views. They have to park their views, essentially. So if they give a big speech with lots of oomph about what they really feel,
well, they obviously
would they not get booted off the bench?
Well, I think they have to show, you know, circumspection and good judgment. That's for sure. There are certain things they should not talk about. They obviously shouldn't talk about, for example, a case pending before the court. How do they think about that?
No.
But I don't think that precludes their talking about broader issues. And to some extent they do. I mean, to give her credit, Chief Justice McLaughlin talks a lot about problems of access to justice, which is a huge issue in this country.
Yes.
That's an issue for her. She talks about it. That's the kind of thing they should be doing.
But she had an interesting trajectory. Is that the right word?
Yes.
Because unusual, a female as Chief Justice in the land first.
Yes, that's right. And she progressed very quickly through the ranks too, from the county court here in Vancouver. As one wag put it, she got to the Supreme Court faster than most cases do. I mean, I think she's a good jurist, certainly. She presents herself in a way that suggests this is not a risky appointment for someone to make. She's not going to embarrass anybody.
Right.
She was a woman at the right time. There are 4 women on the Supreme Court. Well, one has just resigned. But there are 4 women on the Supreme Court of Canada.
Rosie Abella.
Rosie Abella, Marie Deschamps, Louise Charon, and Beverly McLaughlin. Louise Charon now retiring. And by the way, here's an interesting point. I think it's extremely unlikely that Prime Minister Harper will appoint 2 men to fill these vacancies. One of them will have to be a woman, because I think if the number of women on the Supreme Court drops, this would be seen by a large part of the population as a negative.
Well, and as
so
you
may end up there.
I doubt it. With my legal training,
well,
not a chance.
Never
I
say
don't
that.
think I'll end up in the Senate either. It's just not going to happen on this watch. Philip Slayton, our guest, Mighty Judgment, How the Supreme Court of Canada Runs Your Life.